Welcome to At Homes Radio with At Homes Realty Group. I'm Jenny Wood, our At Homes Director of Happiness, here today with our resident home geeks, Dave Troop, and our broker-owner, Elizabeth Cooper Golden. Today we have a very special guest. We have Craig Paulus with Paulus Title joining us today. And Craig, I have to ask, let's start at the very beginning. Where exactly does a closing attorney come into the real estate transaction process?
Thanks. Well, typically in a residential transaction, we come in after the contract, or in the case of a refi, when the deal's pretty much been set and the lender gives us a title order, which is just an order, a request that we start doing our work. If there's something unusual about the transaction, if there's an investor involved, sometimes we come in earlier, but usually it happens right after you sign the contract.
Explain to me what a title search is, because so many of our clients don't understand the importance, and they certainly don't understand what title is and title insurance, why it's needed.
A title search is a search of the land records that exist down here in Alabama. They're at the Judge of Probate's office. What that search does is it looks at the land records to see who owns it, what liens might be on it, whether those are mortgages or judgment liens or tax liens or any kind of liens that might be on it. And we also look for any kind of restrictions. Sometimes there are certain rights that are segregated, like mineral and energy rights. Those can be cut out and separate from the surface rights, the right to use the property. So we look at all those factors. We try to find out what's going on, and we issue a report. Title insurance works backwards. It takes a snapshot of the title at a certain moment, the moment you close, and it covers anything that's wrong with the title before that. So if you buy it today, if there was something went wrong yesterday, that's the kind of thing that will insure. A lot of people say, well, if you've done a search, right, why do we care? Why do I need insurance? Every time the lender gets a loan, they get title insurance, almost every single time. But the big kids still bother to get this.
Right.
The second thing is that there are title claims. They happen, I think statistically, 4 out of every 1,000 policies that are written. So title insurance, it protects the claims of ownership that won't necessarily appear in the land records. For instance, if you're buying a new property and their contractor didn't pay for the bricks, the vendor who sold those bricks, the brick company, can put a lien on the property up to 6 months after the construction was completed. So you could wind up buying a house, doing the closing, and not finding out that there was a problem. Also, unfortunately, while we do hire abstractors who are very capable to do the searches, the number one source of title claims on these title policies, the number one source is abstractor error. The land records are very complicated. Sometimes they're missed, and people make mistakes. So best to be protected against those things. This is your biggest investment, probably, this house you're buying. So it's actually standard here in Huntsville that in the Board of Realtors form, it's standard that you do get an enhanced title owner's policy. All buyers get that, and they share the cost between the buyer and the seller.
So when you're talking about an enhanced title policy, are there different options in title?
There are 2 basic forms that owners need to think about. One is the standard owner's form, and the other is called the homeowner's form, usually called the enhanced form. Those 2 forms differ when you can use them, and because in certain types of transactions you can't get an enhanced policy, like when the property is subject to a right of redemption, or it's a foreclosure, for instance. But the enhanced policy is what the default form I mentioned, the default contract, says you're going to get it if it's available, and expands the coverage to actually increase the amount of coverage by up to 50% of the face amount of the value. So if you buy the house for $100,000 today and it appreciates, you're going to get that benefit of that appreciation under the enhanced policy.
So Craig, on new construction, several builders have struggled lately. In the past year or 2, I've seen it more than ever. And after closing, there have been some liens filed. Will title protect them in that case if a vendor files a lien after closing?
Usually, yes. Usually title insurance is going to cover that. We do a lot of diligence. The closing attorneys do a lot of diligence to make sure that this isn't going to happen. And we get an affidavit at closing where the seller, the builder, solemnly swears that everything's been paid for. And if they lie on that, it's fraud. While there have been builders who've had a lot of trouble, most of them are honest people, and,
right?
And we just deal with the problems as best we can.
You mentioned a moment ago right of redemption. And this is kind of a new market for us as far as more foreclosures being on the market, more investors being active in that market, a lot of short sales. Right of redemption plays a role in all this.
So this right of redemption is a provision that allows, of Alabama law, that allows former owners of property to redeem the property, to buy it back from whoever owns it for a period of time, 1 year after it's sold at a foreclosure sale. The foreclosure means that it typically, by the time it gets into MLS, it's not something that's a foreclosure sale on the courthouse steps. It's something that's already been foreclosed on. Typically the banks make a bid, they buy the property back themselves, and then they list it with some local realtor. Those properties are going to be subject to a right of redemption sometimes, sometimes not, because sometimes they can languish on the market for more than a year, and that right of redemption will lapse. The foreclosure bid price on the courthouse steps, that bid price is our starting point. And when someone comes to redeem, which, by the way, very, very rarely happens, I think Fannie Mae's last year's numbers, they publish a number, it was less than 0.5% of properties are ever going to get redeemed. But when they do, it can cause a mess. They're entitled to pay, or I should say they have to pay what was paid at the courthouse steps, plus taxes, interest, insurance, and certain other statutory charges, and whoever's in the house has to clear out. Now, if you can imagine, that can really cause you a lot of heartburn, finding out that you're going to buy a house and then have to move out. But usually we can work around it. There are a lot of different ways, and it's very situational.
The person that purchased the foreclosure home has made some improvements. Then what happens?
Well, and there's still a right of redemption.
And there's still a right of redemption.
Yeah, we tell people to be very cautious if they're going to make improvements on a property that's subject to a right of redemption.
Yeah, if it has good countertops, just because you want to add granite, you're not going to get your money back for that.
Yeah.
Is that right?
That's right. That's right. I mean, if it's, and you have to do things that fit the character of the house too. And really, I recommend that it only be repairs, not,
right.
If there's nothing wrong with those countertops, even if they're ugly, leave them until the 1 year's up. We do always tell people when their property is subject to a right of redemption. We have to. We always make sure that that's disclosed and that they know what they're getting into.
I know we're a buyer beware state, so what happens if you purchase and you realize there's a defect to the home that you weren't aware of at the time that you purchased it? Is there a recourse for you? It
depends. That's the lawyer answer to everything, but it depends. This is a buyer beware state, and people from other parts of the country who come to Huntsville can be surprised by some of the big differences, and that's a big one.
Sure.
If you're from California, you're used to these lengthy disclosures that tell you everything about the house, and our system can seem kind of unfriendly or quaint because it's buyer beware. I think that you just got to get used to the idea that you go in with your eyes open. Now, it's not totally a buyer beware state. I mean, there are exceptions to that rule. I mean, you can't actively conceal a defect and then smile at the closing table when it's really a defective house. But the notion that somebody's supposed to go through the effort to tell you everything that's wrong with their house, and then you get to back out or whatever, I mean, it doesn't solve any problems in my opinion. I mean, it's just a different way of doing things. You wind up with the same fight. It's a he said, she said, and what did you know and when. I think it's better if we just say, everybody, we're all big kids, you need to take care of yourself. Inspect for mold, inspect for radon. If you think that stuff's silly, don't. But I think that people should get inspections, and
I agree.
And just go in with their eyes open.
Can you tell us some of your biggest hiccups? Seem to be consistent.
Whenever somebody doesn't want to be actively involved in their transaction, that doesn't happen often because I think we have very good communications. But people showing up with a defective power of attorney that they didn't bother to tell anybody about. They show up with a personal check for an extremely large amount of money. I can't take that. It's got to be certified funds. That's in the contract, but not everybody reads it. Those little things. So if you have questions and you're going through the real estate closing process, talk to the closing attorney, talk to your realtor, talk to your loan officer, because they're going to be able to steer you in the right direction.
Who do you represent at a typical real estate closing when both agents are there, who are you representing?
Typically in Alabama, the real estate closing attorney represents the lender.
Right.
Okay, regardless of who's paying the fee. So I represent the lender.
Unless you're hired by the buyer or the seller.
Yeah, and I can
then
tell
you can't do both, correct?
No, you can't do both. You can't be on both sides of the transaction.
Right.
But sometimes we do have, I say sometimes, like in the last couple of years, I've had 3 deals where somebody wanted to have their own attorney at the table. And so they came. And it was always, turns out, because we all know each other, all the real estate attorneys, we know each other.
Right.
It was friends of mine. So we just, enjoyed coffee, and they helped make their client feel comfortable and that everything was adequately explained. And so I've been asked to go represent a client at somebody else's office too. And it's all very friendly and fine. There's nothing, it's unusual, but there's nothing wrong with asking for that if you want it.
A lot of things have changed in the past few years, and a lot of our clients out there haven't closed on a house in years. My own house, the last one I bought was in '99, so if I weren't in the business, there's quite a bit I would not have seen at this point. There's a little insurance notification form at the end of closings now. Talk to me a little bit about that. That's brand new.
Oh, yeah, that's an Alabama thing. And I think it was Ben Franklin who said life, liberty, and property are not safe when the legislature's in session. The biggest part of my job, the most important part of my job as a closing attorney, is handling all of this money that's other people's money. And what if a closing attorney does something he shouldn't do and takes that money? Well, the closing protection letter is essentially an indemnity insurance, and this indemnity insurance is from the big title company. If I do something wrong, Stewart, who has $800 million in reserves, is going to make it right. That's what the ICL says, is if the closing attorney does something wrong, they'll make it right. Now, it's a big deal, and up to this point, that up until last year, they were not allowed to charge for that because of government regulations that said title insurance companies can only sell title insurance and not indemnity insurance, so they couldn't sell it. They had to give it away for free. Now they sell it. It's $25 per policy. And sometimes I guess it's $50 on certain people in certain circumstances. But basically, it's a good insurance to help banks and everybody else feel more comfortable.
So much thanks to our guest, Craig. He offered such great tips and advice today. Craig, how can we get in touch with you? How can listeners get a hold of you?
Well, you can find us at pauluslaw.com or paulustitle.com. Our law firm is more of a traditional legal practice. There are 4 attorneys, and we do more than just real estate. We do real estate, we do banking, law, evictions, and we do a little bit of simple estate planning and things like that.
Well, fantastic. Thank you so much for joining us, Craig. And thank you to our listeners for joining us on At Homes Radio. Next week, we'll be answering all of your questions, so be sure to send them into questions@athomesradio.com, or you can reach us directly at 256-585-6000, and we'll see you next week on WVNN.